They discussed and debated the evidence among themselves before arriving at their collective decision. After their exhaustive review of the evidence, the grand jury deliberated over 2 days, making their final decision. They determined that no probable cause exists to file any charge against Officer Wilson and returned a no true bill on each of the 5 indictments.
That, of course, Prosecutor McCullough down in the county where we find Ferguson, Missouri, announcing the no bill in the Officer Wilson case. Joining us to dig a little bit into the process and what actually took place here in the grand jury room, we're going to talk with Doug Burns, former federal prosecutor, TV and radio legal analysis. Doug, pleasure to have you today.
Thank you, Rick.
So I want to dig in a little bit into the process here.
Of course.
This was a very unusual grand jury session.
Extremely unusual, because not that it's a dark secret, but the reality is most grand jury presentations are very quick, couple hours,
Right.
A couple summary witnesses. Hearsay is admissible, although within reason, you don't abuse it. But the point is here, you can look at this from any number of angles. You can be cynical and say, they did an exhaustive, extensive presentation to insulate themselves from criticism, or you can flip that right on its head and say they did an exhaustive presentation, which is a good thing.
Well, the reason that it's usually such a quick process
Yes.
is the prosecutor sets out what he wants.
Exactly.
And unless there's something really glaring,
Yeah.
the grand jury is going to go, okay, because that
But
person's still going to get a trial.
But the key distinction you got to remember here is that this is a case with a legal defense, and that creates so much confusion in the public.
Explain legal defense.
Okay, in other words, let's say you have a case and you're not sure whether the particular person did the crime or not, and you have identification and witnesses. The issue is, did he do it or not? Here,
We know he did it.
definitely shot the person.
Right.
And by the way, it's a pet peeve of mine when people say he killed him, or they take it to the next step, he murdered him. Murder is a legal term. He shot and killed him. That doesn't mean he did a crime. It doesn't mean he didn't do a crime. Let's be fair.
In this case, murder is indeed in the eye of the beholder.
Exactly.
Isn't it?
And so with a legal defense, here's the problem. Lawyers are advocates. So in a grand jury room, you do not, and you've heard this, all the commentators, but I did many grand jury presentations as a federal prosecutor. No defense lawyer, no judge, no meaningful other side of the case. So here the question is, did the prosecutor somehow editorialize?
Well, this is what's so abnormal. As you correctly point out, no defense attorney.
Exactly.
So you would think that the officer would be at a disadvantage. He's got a prosecutor coming at him and nobody to defend him. But yet this time,
let me give you 2 examples.
Wasn't quite that way.
You're in the grand jury.
Yep.
I'm the prosecutor. My first presentation, these are hypotheticals, is if somebody is retreating with their hands up in a defensive posture, you're not allowed to kill them. The second presentation is if somebody is brutally attacking you, punching you in the face in the car, and I think the viewers understand, the point is there's 2 ways to pitch any legal fact pattern. And so we really need to know, look, the other thing that's highly unusual is to disseminate the evidence before the grand jury.
Yeah.
You never see that. And the reason, of course, is that grand jury proceedings are secret to avoid impugning people's integrity if they're under investigation and then exonerated. Here, I'm sure there have been lots of redactions. I haven't seen the material. I'm sure the judge had to order it. But the point is, these prosecutors, it's a 2-step analysis. On the one hand, they're confident enough to put the material in front of everybody. But I like your thinking, which is, wait a minute, though, that really doesn't answer the whole analysis.
Using your 2 examples.
Right.
Again, typically we would imagine that it would be the prosecutor who'd be taking that.
Of course, but they don't
But
when the
that's not
defendant's
what
a law
happened
enforcement
here.
officer.
Right. What happened here, and I've read the
No.
transcripts now.
Yeah.
This is really what's ultimately going to bother people, I suspect. If you are somebody who doesn't feel good about this officer walking away without an indictment, this is what's going to bother you. It does look like. You don't have the benefit of inflection and all that, but it looks like this prosecutor went pretty darn easy on the defendant.
Your point is so interesting because people should understand that regardless of how you view the facts, it does matter the way you present it.
Yes.
But by the way, let's look at the case dryly, real quick, nothing complicated. To me, it's a 2-part fact pattern, and you got to look at part 1 and part 2. Part 1 is reaching into the car. I don't think anybody can seriously maintain, after studying the evidence, that the victim didn't reach into the car. And so the officer shot him and grazed his hand. That's fine, but that's not the end of the story, because ostensibly that fight could have ended. And then he's elsewhere. You and I talked about this many times in the context of the Trayvon Martin case. So the real question, real simple, is was he charging him or was he retreating and surrendering? It's that simple. That's the whole case.
And from what we see,
the whole
there
case.
was conflicting evidence.
Absolutely.
And when there's conflicting evidence,
A jury should decide it, is the argument. Reading your mind. And
which,
you're right.
Which
In other words,
means it should have gone to indictment.
any witness
and
said-
it should have gone to a trial.
if any witness said he was retreating, then theoretically a trier of fact
Yes.
has got to
Even
decide that.
if you question the validity of that
well,
witness.
there may be, but let me defend the prosecution just from one standpoint.
I'm not going to be able to let you
No,
because I'm
that's
out of
fine.
time. We will do this again, though. This is one of my favorite discussions,
My
as you
pleasure.
know, getting into process. So we got more coming up next, and we have got our friend, Democratic strategist and Newsmax analyst, Hank Scheinkoff joins us right after this. Don't go anywhere.